I'd like to welcome all of you back, and I'm very pleased to introduce Judge Johan van der Westhuizen, who will facilitate this process. Johan van der Westhuizen was a professor and the head of the Department of Legal History, Comparative Law and Jurisprudence at the University of Pretoria's Faculty of Law, as well as the founding director of the University's Center for Human Rights. He is currently an extraordinary professor at the University of Pretoria and an honorary professor at the University of Cape Town. As an academic, van der Westhuizen has taught widely in South Africa and abroad, including at Yale Law School in Germany and at McGill Law School in Montreal. Presented numerous papers at national and international conferences, authored and edited several publications, and participated in numerous radio and television programs in the USA, Germany, Canada, Japan, and South Africa. He was admitted as an advocate of the High Court of South Africa and was an associate member of the Pretoria Bar. During the drafting of South Africa's constitution, he was a member of the independent panel of recognized constitutional experts, which advised the Constitutional Assembly, and of the technical refinement team responsible for the final drafting and editing. In 1999, he was appointed by the Gauteng High Court in Pretoria. He joined the Constitutional Court of South Africa on 1st April 2004. His non-renewable 12-year term on the court expired at the end of January 2016. Thereafter, he was appointed by the President as the inspecting judge of the Judicial Inspectorate of Correctional Services. We'll leave the panel.
Thank you very much to the organizers for giving me the opportunity and asking me to chair this panel. It is a huge privilege and an honor for me. And before we proceed any further, I want to inform you about the arrogance of a judge who is used to making orders. The judge was sitting there, and normally judges like peace in their court, but I was profoundly disturbed by the fact that everybody seemed to agree and that there's no controversy. So when I heard Ms. Bulelwa Mabasa and Stephen, is Stephen here? Stephen still here? No, I don't know. You see, that's the problem with people criticizing the Constitution. They do it and then they walk out. So to make sure that she doesn't walk out, I said she'd join us right here on the panel, because I was disturbed by another factor also, and that Professor Majola rightly started talking about the importance of inheritance and land for women, and nobody further has said a word about it, and we have heard very few women, if any. So I think to hide my own white maleness or male whiteness, I decided to change the composition of the panel. I did consult, but after consultation, I made an order in any event. Now, talking about more controversial views, I saw we have some guests who want to join us. Now, why are they not here? I specifically asked them to come so that I can give them an opportunity to speak. Are they around? If they come later, I hope they do so quietly. Tutu, are you in touch with everybody who's relevant? Yeah. Okay, we were talking earlier about the mountains and the sea. I know Mr. Malema already said we must rename the Atlantic Ocean. He didn't mention the Indian Ocean because that would, of course, sound like there's a racist element involved. But I recently on the radio heard a very stupid joke, which was told by an Afrikaans joke comedian, storyteller. So I don't know if the joke will even work if I try to quickly translate it in English, but it deals with oceans and mountains. They said this group of men was sitting somewhere in the Western Cape, and they were going to watch rugby on Newlands. We can also say they were going to watch soccer in Greenpoint, but they were having quite a few drinks, and they rented a combi bus for the occasion, and they then decided to drive to Cape Town for this sports event. But as they were taking refreshments at a At an amazing speed, they became more and more friendly, and by the time they got into the combi to drive to Cape Town, they were singing. And they started to play a game. One of them would shout a word, and then they would sing a song immediately about that word. So the one shouted tree, and then they would sing lemon tree, very pretty, etc. And one would shout rainbow, and then they would sing somewhere over the rainbow. One would shout ocean, and then they would sing My Bonnie Comes Over the Ocean. And just as they crossed the train track into Paarl, everything went completely black, and it was lights out. And they all woke up in the hospital 3 days later, and they were told that a train struck the combi, nothing remained of the combi. The only thing they could retrieve was the rear view mirror. But amazingly, all of them were unscathed except for small injuries. So when they got together, they were discharged from the hospital. And they sat there and they said, well, now there's just been question. This match that they came to attend actually was played 3 days earlier. And the gates to the stadium are locked now. And what are they going to tell their wives and other family members about where they were? Because they could remember nothing. They could remember nothing. And the one guy said, well, I now start to remember. He said, we were singing these songs, said tree, and then we sang lemon tree and so on. And he said, and just when we went into Paarl, somebody looked to the right on this train track and shouted, train! And then we all started singing, chukka chukka train, chukka. Anyway, the original owner of Table Mountain, if I were that person, I would have insisted on a market-related price, because I would assume it is prime real estate, if one has to. Let me say something quickly about our speakers. And I think even before I go further, we have not introduced our latest panel member, whom I adopted here to the panel, or co-opted, or what is the word? I think she can introduce herself. We know that she's with Werksman's attorneys. We know that she's an independent thinker, and she can tell us more when she gets an opportunity to speak. What I think I'll do, I'll make a few introductory remarks, and thereafter, Professor Johnson has not spoken. The other 3 panel members have spoken already, so perhaps they can wait a bit and we take more comments from the audience. As far, there seems to be alarming unanimity about amongst the speakers that the Section 25 that the Constitution has to be the starting point, that it is at the core of the discussion, that Section 25 is the relevant clause. So far we've heard the opinion that there is no need to tamper with it, amend it, abolish it, but that the slow pace of land reform, the lack of delivery, is the fault of the administrators and the politicians and of a range of things. So we have heard that market forces certainly not dominant, that all factors have to be taken into account, and that as it stands even, Section 25 does provide for compensation even with, for expropriation even without compensation. I will get back to that point because it's an interesting one. My friend Machaca, who now for the second time praises me by putting me in the same category as Beyers Naudé and other struggle icons, for which I always thank him. In fact, it's the only part of his speech that I agree with. We know, is it Bryson who wrote the book, A Short History of Almost Everything? Now, Matoli always gives us a full history of completely everything. We met in Germany in 1983 already. The Germans invited us to an event hoping that we would fight, but we didn't. Generally today I agree with him. I found your presentation very entertaining as well and interesting. I do disagree with you. I don't think Noah really existed. I think it is a poem. I think it is a poem about faith. But somewhere some racist lines slipped into this poem, and that is about the booze up afterwards, where they decided to punish his irreverent son by making him black. By the way, I also don't believe that, I see Father Nell is here, I don't believe that Adam and Eve existed, although I think it is another very, very nice, beautiful, useful poem about where we come from. And my last remark is, Dr. Machaca said he has serious doubts about evolution, because if apes have evolved into human beings, why did this process stop? And he specifically said, who put an end to this rather important project? I have two possible answers. The one is that the creator, her or himself, saw what human beings have become and decided to stop the project because the earth can do better with apes. And the second possible answer is that the apes, of course, saw what human beings are like, and they said, you make your own human beings, we're not going there anymore. Anyway, as far as the Constitution is concerned, Section 25, yes, it was... I expected earlier that people actually would question the legitimacy of Section 25 and the Constitution. One or two very brief remarks. Section 25, from my own experience, because I was there, I was not specifically on the Section 25 committee, and in fact I tried to avoid them as much as possible because they were always fighting. In the interim constitution process, as well as the final constitution, it was a very, very, very difficult committee because of the history. Dr. Machaca spoke about part of it. In the run-up to the constitution, remember now, South Africa had 3 centuries of parliamentary sovereignty, or at least formally since the British took over, where what Parliament decides is the law. You cannot question it in a court. Parliament decided apartheid was the law. Forget for a moment the fact that Parliament was elected by 15% of the people or something like that. But Parliament made laws. Judges said, some said we like these laws, others said we don't like them, but there's nothing we can do about it because parliamentary sovereignty prevails. Parliament made the laws. So in the run-up to the Constitution, at this very conference that Dr. Machaca spoke about at Pretoria University in 1986, he arrived with a leopard skin around him and upset all my white brothers who thought this is the day of the long knives now. And he brought with him a group of young people who call themselves the Anti-Bill of Rights Committee. And they, as well as others, raised a very legitimate question. They said, hang on, what are you planning now? You're planning... we have had 300 years of parliamentary sovereignty. Now you want a constitution with a Bill of Rights. Yes. Who are going to... This Bill of Rights is going to bind Parliament? Yes, they cannot make any law they want. It's going to bind the president, who is likely to be Mr. Mandela. Yes, Mr. Mandela. The courts can review what Mr. Mandela is going to do. And Parliament? Yes. They say, which courts? These old judges who were white male judges, all appointed by the apartheid regime? Yeah, them, but we'll make a plan. So eventually we came up with the idea of a constitutional court. But as far as the contents are concerned, they said, now what rights are you going to protect now? Right to life, we will all agree on that. Right to a fair trial, we will certainly all agree to that. Right to freedom of expression, yes, it's important. But, you know, for the mama who carries wood on her head in Limpopo, it doesn't mean that much that she will now be entitled to see pornography on the stage of the State Theatre in Pretoria. She's unlikely to get there and to have this huge new freedom. So are you going to include the right to property? Yes, because it's internationally recognized. How much of the land belongs to white people? Well, you know, what was the percentages? 85% belong to 15% or whatever. So if Mr. Mandela or Parliament makes a law, then the old judges will have to decide whether it's a good law or not. Now, of course, I'm grossly oversimplifying, but the idea was that this Bill of Rights could easily become a bill for whites instead of a Bill of Rights. In other words, it could protect white privileges like property. One of the things we did, or that followed from this, is the fact that we included in the Constitution, when I say we, I don't mean myself as one of the drafters, but we as South Africans, included socio-economic rights. Housing, healthcare, education. And therefore, the one point I want to make is the property clause, of course, has to be read together with, for example, the right of access to housing. We were very careful in drafting those. The Constitution does not say you have the right to a house. When Mr. Mandela's cabinet was appointed and Minister Joe Slovo became the Minister of Housing, those of you who are students from elsewhere will not necessarily know, but we have a character in South Africa called Miss Evita Besuidnout. It's a comedian, a man who dresses up as a woman and then says all kinds of funny things, mostly about politicians. And Evita interviewed Joe Slovo. The interview took place in a swimming pool. And Evita said to the Minister of Housing, so are you promising to build 1 million houses in 5 years? And Mr. Slovo said, yes. And Evita said, are you sure it's not 5 houses in 1 million years? So we had to be very careful that the socio-economic rights do not amount to empty promises. So the right to housing is not the right to a house. It is the right of access to housing. We can come back to that later. But some of the land questions, especially when you talk about urban, are closely interrelated with the right of access to housing. The property clause, therefore, yes, it was a compromise. It was a committee on which the members on the same side of the committee often accused each other of selling out and so on. My view at the moment is, open to be persuaded otherwise, is that the fact that the Constitution was a compromise, by the way, that made us into a nation and avoided a civil war. But the fact that it was a compromise does not mean that it was selling out. The parties were represented. The IFP walked out, and the far right-wing Freedom Front, with their 5 members or whatever, abstained, and all the others voted for it. So, of course, a compromise, which does not mean sell out. However, when it comes to Section 25, and I throw this out now for discussion. By the way, let me also just say, not only have I co-opted Ms. Mabasa, but I actually would like to co-opt the entire audience onto the panel, because I think we have heard enough from specific speakers. So let's give them an opportunity, and I will give every one of you a chance to come in. But from my simple understanding, Section 25 does not really recognize the right to property or the right to own property. It protects against arbitrary deprivation of property. And that is quite important. One can argue that it is semantic and it doesn't mean that much, etc. But the question was not so much, do we now all have the right to own a farm? The question was, do we have access, and how can we be deprived of? Very important, the process must happen by law, Section 25. Then it says, it talks about compensation, and then later on, let's look at question quickly about if I understand Professor Majola correctly and others, it says expropriation, it mentions compensation, subject to compensation. Then in 25.3 it says it must be just and equitable, and then it mentions all those factors, of which market value is only one. And then the important part is 8, as you said, that this argument, by the way, we also find with regard to the equality clause. The equality clause says everyone is equal, no discrimination, no unfair discrimination, in fact. So the question also there comes up, can unfair discrimination still be justified as a limitation in terms of Section 36, the limitation clause? But let's not talk about section equality now. I will do it with the students on another occasion. I think the argument is, and Professor Majola and others can come back, that even without compensation, it can be a justified limitation of the right not to be deprived arbitrarily. Now, I don't think we can go as far as saying a law can even arbitrarily deprive of property, and then that arbitrariness can be justified in terms of the limitation clause. That would be too much of a conflict. That is by saying even unfair discrimination can sometimes be not justified, not unfair, not fair because it's unfair. but certainly one can reach a point of no compensation, the way I understand it. Under 25(2)(b), one can reach the conclusion of very small compensation, but under 25(8), even no compensation. However, it will then have to comply with the limitations clause. In other words, it must happen by law, not the decision of the president or any administrative officer, and that law must be law of general application, not only apply to whites or blacks or whatever, and that law must then be justifiable in an open democratic society, as the limitation clause tells us. So that's a small nuance. I will come back to the right to property. I've mentioned that. By the way, 1 or 2 court cases that we have had, that part of Section 25 saying it does not only property is not only limited to land, that is 25(4)(b). Quite a number of cases before the Constitutional Court, one in which I wrote the judgment, and therefore I remember it well, had nothing to do with land, because certain rights can also be property. And that's what land experts in the academic world tell us. So the judgment I wrote, which was based on the National Credit Act, and it had to do with transactions where something goes wrong, it is too long and complicated to explain, and whether you lose your right, which you would under common law have under unjustified enrichment. It seemed as if the Act took that right away, and we actually ruled with a majority decision that it does violate the right not to be arbitrarily deprived of property. Another one which gave me not sleepless nights, but made me very sad: urban property, not land. You know, we had the Group Areas Act. The Group Areas Act, somebody did mention District 6, I think it was Mr. Machaca, and that is the case of Florence. Mrs. Florence and her families, they were so-called colored people in Western Cape. They bought a house in 1970 in Rondebosch in the Cape. They paid for the house in full. They lived there with the family. Then the Group Areas Act kicked in, and they were kicked out of the house and paid something completely ridiculously low, nothing to do with the value of the land. Now, in terms of the Land Restitution Act, the question is, what do you do 40 years later? 40 years later. So what made me kind of sad is the case dealt with a way to just to calculate this, what is in the constitutional called, what is it called, the compensation? Yes, but just and equitable, for example. Yeah. And in the land. Now, how does one calculate what is just and equitable 30 years after a family had been kicked out of their house? So, in the Land Claims Court, there were experts, economics professors, statisticians, etc. They were presenting expert evidence on which method to follow now to calculate. And they eventually decided that the Consumer Price Index, the CPI, is the correct way. Mrs. Florence and the family appealed, and they said, no, the Consumer Price Index itself is a method which is skewed against poor people, because it presumes a basket of food that you can in the first place not buy, even if you... but what are the alternatives? The other alternatives were things like the 32-day notice deposit account. So we were split. It was my judgment, but eventually I had a minority with me. We wanted to say the 32-day notice deposit account because it would give Mrs. Florence a little bit more than the Consumer Price Index. The majority of my colleagues said no. This is an imperfect situation in any event, and we must remember we use taxpayers' money now to pay Mrs. Florence. It's not the people who originally benefited. So what left me, quite honestly, I didn't really care very much between the consumer price index and the 32, because all of that looked ridiculous to me. To have 40 years after a family have been kicked out of their house, the children out of the school, moved to wherever, now you have professors in statistics to give evidence on which accounting method should be used constitutionally. And that led me to the question which I've asked with regard to other cases as well, but I actually opened this judgment with a quote from the famous novel The Great Gatsby by Scott Fitzgerald, where he says, where the narrator says to Gatsby, but you cannot repeat the past. And then Gatsby says, why, of course you can. So my question in any event is, to what extent can the Constitution and the law repair the past? We see that problem with Truth and Reconciliation Commission. We see that problem with affirmative action. Anyway, that's an example of urban, and where one is really just left with a feeling of hopelessness that, by the way, this family also, they asked for something else. They asked for a small plaque on the property to commemorate the family, the fact that they once lived there. The court decided against it. The lower courts, as well as my court, the majority, not saying, but there is already a District 6 museum. Is that too much to ask? A plaque to say the Florence family once lived here. But anyway, back to our biggest problem. I think at the core of these questions is indeed the question whether the problem starts with the Constitution or not. Professor Majola said, and I fully agree, the Constitution must be interpreted contextually and purposively. So whenever you interpret Section 25, you have to take into account our history. That cannot take you so far that you ignore the very explicit words in Section 25. So that is where we come to whether it is a problem or not. So what is the reason why we have made so little progress? And I fully agree we are sitting on a time bomb. Remember, it is linked to poverty in general. It is linked to dignity. It is linked to people's self-esteem. It is linked to this whole ongoing system of bosses and peasants, of people working for other people. I'm not saying any of those things in itself is wrong. The Labour Relations Act is there, or there are lots of other legislation. But the question is it the Constitution? Is it a lack of resources? Is it lack of a political will? But you know, even that for me is a bit of a euphemism. It actually softens the question. Lack of political will seems to me that the politicians think politically it's not the right thing to do. And that is not the same as simply being too lazy to do it, or too slow, or too lackadaisical. If one does not do things for over 20 years, is it because politically there is some objection? I don't know. Does anybody in the ANC, the majority party, want white people to remain in control? I don't know. Perhaps. I don't know. You never know about the influence of white monopoly capital and so on. But you never know. Or is it just like in many other areas, not enough has been done? Now, if that is what Dr. Machaca says, then why? Is it because the administration is too slow? It's because the legislation created too many loopholes and too many obstacles? So those of us, like our new panel member and Stephen, who said perhaps the Constitution is the problem, who at least asked the question, let me state my general view about a Constitution. Certainly a Constitution is not cast in stone. It can be amended. Therefore, there is an amendment clause in the Constitution, Section 74. Which tells us how to amend it. But certainly a constitution is not just an ordinary piece of legislation which every government can amend, repeal Obamacare, bring in Trumpcare, or not bring it in, or that is not what a constitution is there. That's why you need a 2/3 majority, which the governing party at the moment probably does not have, although one is not sure. So how long is it going to take Remember, this is part of the Bill of Rights. And according to Section 74, the Bill of Rights is more difficult to amend than another clause. Not as difficult as the founding values in Section 1, but if you can link property via international law to fundamental values and rights in Section 1, then you will even need a 75% majority. Probably not. Probably 2/3. But the problem is, this is going to be a very difficult process. Apart from my principal point, namely, which is influenced by my age, namely that we should not amend the Constitution just because you feel like it. And you should certainly not propagate it for populist purposes. So those who say the Constitution may well be the problem, I have wide open ears, but I would like to know why. Stephen's point, I think, is very important, but this point that the way it is drafted, read with the rest of the Constitution, actually causes the other legislation to be complicated. Please help me to understand how, and show me in Section 75 what is the problem that causes politicians and officials and land claims court procedures to be slow. I don't know what, but I'm sure we will have the answer. Enough from my side on that. I think what we must do is give our real panelist, Professor Johnson, a few minutes, and then with Ms. Mabasa, and then we will open it up for other panel members and for the audience. Thank you. I am not going to in detail introduce Professor Johnson. His CV is here. He is the convener of this. He is the head of the George campus of the Nelson Mandela University. His background is actually in medicine, but as far as I understand, he is an expert in many related fields. So, thank you.
Thanks very much, Chair, for that wonderful explication and the humor that you have introduced into the space. Let me perhaps just begin by saying that I was born in District 6. And so when you think about District 6, those who were born there and understand the narrative, you will no doubt know that it's an extremely painful one. I suppose, much like the pain of very many others in very many other spaces and places where our dignity was impaired and respect for our beings was all but demolished. And so, those of us who have lived that experience really, take the matter extremely seriously, as we all do here. When I hear a judge speaking about understanding whether some members from the audience can provide a better explication for why they may think that there is a problem with the Constitution and Section 25 and so forth, I think we need to deal with that as clearly and as succinctly as is possible, so that there is no confusion that the Constitution and Section 25 can in fact help us to address the land question. Because I think we all know, as the judge has said, we're sitting on a ticking time bomb. People are becoming extremely frustrated and agitated and angry. Just last year, as we engaged with our students in the protest action, they looked at us and they said, fees today, land tomorrow. And when we look at all of those, there's a clear and sentient call for urgent action to be taken. Now, I've heard that we don't quite understand why we are so slow to take this action of redistributing land within the framework of the Constitution. I've heard about administrative systems that may be inefficient. I've heard about the challenge of cadre deployment and skill specialization to understand what the nature of the context is so that we can move this matter along. I think these are very important matters that we must address, and we must address it with urgency. I've heard about the church, for instance, reverends that are here, the interfaith community, the church in particular, that have vast tracts of land, and I'm particularly keen to understand how the faith communities feel about, contributing to the redistribution of land that is so necessary. I'm very keen to understand the young people's view inside of this audience in particular. Because whilst we are arguing about the technical, legal merits or demerits regarding Section 25 and enabling legislation and so on and so forth, we need to make progress. And we need to come by these technical and other interpretive obstacles so that our people, because in the end it's about our people. The law is very necessary, but we all know that the law can be quite clinical. In the end it's about our people and how we feel about ourselves, and our identity and our place. I think Professor Machaca spoke very eloquently about the African people and the African genius just, this morning, amongst others. I think that our keynote speaker molecularly dissected Section 25 in a superb fashion to help us understand its meaning and its force and implications. I think Advocate Makua did a superb job in helping us understand what the processes are related to this section and how, unfortunately, bureaucratic, Advocate, those processes are that in fact delays the implementation that we all so significantly seek. And so when I think about all of this, Chair, I'm left with the sense that when we leave here today, we should certainly leave here with a reasonable and rational understanding of what we will do to accelerate the redistribution of land within the context of our Constitution. And that the matter of the technical, let's say, interpretation of Section 25 is important. But I'm beyond that point at this time in asking what would the solutions be to bring home the matter of land access with regard to the national question. I think for me that's important because I don't want us to get lost, in the important technicalities of Section 25. I'm sure we have tremendous expertise here that will help us to deal with that. But when I go home tomorrow and I have a meeting with my students and other stakeholders, I'd like to be able to say to them, when we had this particular symposium, it was magnificent to actually hear the very practical things that we can do to advance access to land lawfully. And for me, that's a very important matter to take away from here. Oftentimes, as professors, we are quite esoteric and theoretical, but we have moved way past that point to this particular urgency, where we must make hope practical and despair unconvincing. So, Chair, with those few opening statements, perhaps we could put it to the floor, and our panelist here, who has joined Ms. Msaba, to have some of her views, and then to really, enlist and co-opt, as you said earlier, the entire audience as part of the panel, who we'd really like to hear, most of their views. Thank you very much.
Thank you. Thank you very much, Professor Johnson. I think the very important point is that we have to talk about the way forward. Of course, in order to do that, we have to identify the core of the problem, but the way forward. So whether we move past the point of the Constitution or not, there is work to do, and the question is, what is the next thing to do? The students in the African Democratization and Human Rights course, is there somebody from Zimbabwe in the group? Yes? I don't want to put you on the spot, but people will always ask, is the Zimbabwean option a viable one? Or something similar to that. Anyway, our next panelist, Ms. Mabasa.
Thank you, for Professor Johnson. I think for bringing us home, basically. And I say for bringing us home because I don't think the land question can be reduced to rules of interpretation, the luxuries that us lawyers have in our fancy buildings and arguments in court. I think it's important to bring the discussion home. So my very kind of scantily noted notes, I'd like to begin by saying my proposition to say let's have a paradigm shift certainly is not I'm not propagating for an amendment of the Constitution, nor am I saying we should amend Section 25. Where my focus is when we talk about the right to property, and thank you, Judge, for clarifying the point, is that there is no right to property in the Constitution. The property clause, when it comes to ownership, is written in negative terms. So it says, no one may be deprived of property arbitrarily. So as it stands, there is no right to own property. And I think that follows on from my earlier remarks that says why we seem to have an obsession around individual ownership. Already as it is in our law, we have different forms of access to property. You have leasehold, that is a recognized right in our law. So that's just a nuance that I'd just like to introduce, to say when we speak about property, let's not think about it only in terms of individual property. Saying that, however, is not a deviation or a critique against the Constitution itself. And then my second issue is around, there needs to be a national dialogue on land. I think the way that we've been phrasing the arguments and the debates is quite divisive. When we talk about, even in the Constitution, I would also venture an argument to say even the phrasing of the property clause is divisive in itself, because one has to look at whether or not someone is historically disadvantaged. So it is currently phrased in a way that there is us and them. You could either be a property owner or you could be historically disadvantaged. I'm proposing an argument that says that on its own is a tension. I think we need to move to a place where the national dialogue says, as the people of South Africa, we have to see the critical need for land to be equitably distributed as much as possible. So it needs to be a national project that is not about political party ideology, that is not about race. So it is about us, the people of South Africa, see the need that will benefit all of us, white, black, colored, Indian, etc. The land project is such that we must all buy into it. And if we all buy into it, it will not be difficult for us then to give up the idea that I must be an individual owner of property, because we will be faced with a public good that we've all bought into. So that's my proposition. And I think the same argument could be stretched to notions around transformation and BEE. And if we all understood that the more people that we have as South Africans in the majority who have a sense of dignity, who have access to work, it will all make our lives all improve and all beneficial for all of us. So the reason that we find ourselves holding on to either I want to own my property as an individual or I need access to land as a community is precisely because we have not married those two tensions together into a unified national issue. And so I think that in us debating these questions, whether it's BEE, affirmative action, land, we're missing out on one thing, and a voice that I find slowly dissipating and that is quite divisive is that we have not placed the reconciliatory agenda at the forefront of all these needs. And I think that has to come back. And when we speak about the reconciliatory agenda, we are not talking about the fear of debating the pros and the cons of the way that Section 25 is crafted. We are actually talking about how do we leapfrog from two divisive positions of difference into crafting a future for South Africa that is got a singular and unified vision. So this is where my premise would stem from, is that the land question does not belong to the ANC or the EFF or to white people or to farmers or to business people. This is about the project of South Africa. This is about South Africa Inc. as if you had to think of the country as a company, where is South Africa Inc. going? And have we made enough strides to make the land question not just about the groups that are divided, but as a unified project that can benefit all of us, for the betterment of all of us?
Thank you very much. I think let me give the other three panelists only 1 minute each for now, and then we bring in the audience, and then everybody can participate. Audience, panel members, just please do it through the chair. I will try to be as fair as possible. Yes, Professor Majola.
Well, what I just wanted to mention is the issue of whether property can be expropriated without compensation. I'd like to say yes, it can, but not arbitrarily, because I think that the provisions of Section 36 require that it must be justifiable in an open society. And I think that rules out, even if it's without compensation, it rules out the arbitrariness, because it should be justifiable in an open and democratic. If we give meaning to democratic, yes. I think that we could avoid that. And then, Judge, you said that there is no right to property. I do agree, but I've looked at Section 27, which says that everybody has the right of access to health care. And then also looked at Section 25(5), which says that the state has an obligation to take measures to create conditions that are conducive to helping or enabling people to have access to property. And wondered whether we cannot say that there is some obligation or there is some right that the community has, which the state has to give effect to. Otherwise, what would be the meaning of 25(5)? Yeah.
Okay.
My 1 minute is up. Okay, thank you.
No, I want to ask you a question. Let's not get bogged down into semantics.
Yes.
Maybe it's not even that important whether it is a right or not. But can you, for the purpose of the audience, give us an example of what would be arbitrary deprivation? I think between you and me, we agree that even the limitation clause could not justify arbitrariness. So what would, for example, be an example of arbitrary deprivation of property?
That's a difficult one. Well, my sense is that if the legislation passed does not meet the requirements of, if the deprivation is not justifiable, I cannot just think of an example in an open society. In other words, if we ask, is this legislation which permits deprivation justifiable in an open society and democratic society, and the answer is no, we would then say it's arbitrary.
If the legislation passed says the president can decide whose property will be expropriated and allocate property according to his discretion, something like that.
Something like that.
Yeah.
Yes.
Yeah. So arbitrary, just like arbitrary arrest.
Yes.
If the cops just pull me out of my car and say we lock you up for the night, that's arbitrary. Yeah.
But yes, but
And that can never be justified.
No.
The word itself militates against it. Yeah. All right. Thank you. Yeah. Who's next?
No, I think that the requirement of a law general application already covers us, because such a law would not allow a head of state to wake up and say, today all colored land is going to be grabbed or all Indian. I think it covers us. But also, arbitrariness, by its nature, the rule of law is meant to prevent abuse. legal arbitrary actions. And that's why there must be legal certainty. When you sleep, you must be sure that the following day the law that is applied to you will equally apply to all others, regardless of their race, creed, and so on. But lastly, I think I like this idea of South Africa Incorporated.
Of course, it must come from somebody working for Werksmans or some big firm to think in those terms.
You see, and I think that's what the people of South Africa intended at the beginning. Because in 1955, it was the Colored People's Organization, the White Democrats, the South African Indian Congress, the African National Congress, all four racial groups came together to adopt the Freedom Charter. Now, that's what we should continue doing in line with this idea of the South Africa Incorporated. Because, you know, for some of us to stand up and say, if white people march, it means this march is racist. It can't be correct. Actually, we need more marches with all race groups participating, because we are saying no government will be justified unless it's based on all the people, both black and white. So if it's only Africans protesting or colors protesting, it doesn't meet that requirement.
Don't you appreciate the courage of an ANC Member of Parliament? Yes, Advocate Machaca. You cover. All right, I will open it to the audience, but a question for Ms. Mabasu, I didn't quite follow. She can come back a little bit later. If you say the clause is unfortunately drafted in a us and them kind of fashion, I don't know if it's possible to draft it because you have to deal with those who have and those who have not. But if you say that is unfortunate, but at the same time you say you're not advocating a new Section 25 or an amendment, do you mean that by its interpretation and application we can move away from that kind of attitude? But think about it, we'll come back. Yes, audience now, this is different from the previous session where it was mainly questions. Here you can make your statement. It will be good if your statement does embarrass one of the panel members or put them on the spot. This gentleman here, are you going to help? Yeah, thanks. This gentleman, then behind, and then here. Let's just stick to those three for now. Anybody is welcome. Just introduce yourself and then, yeah, and not too long.
Good afternoon, ladies and gentlemen. My name is Kumo. I'm a fourth-year student at the University of Pretoria, law student, of course. I just wanted to point out something that has come up. It is relating to the question relating to land reform, alongside the question of public interest. And one thing that did come up earlier, before we went for lunch, one of our speakers was making reference to how some of our municipal managers and some of our powerful figures in the municipal spaces are not very clear in how our land use models should operate. So we look at the city of Tshwane, for example, home to approximately 3.5 million people, and a certain number of them are obviously living in informal settlements and the likes. And a lot of open land around our city urban spaces is being allocated to industrial warehouses and manufacturing sector. That question brought up something else with regards to our land use models that I think we tend to overlook, is how do we want our land use models in our spaces, especially in urban spaces. And Stephen did bring up the urban and rural question with regards to our land use purposes. We need to become a lot more clear on how we want to utilize our spaces in urban spaces, because another thing that's taking place in the midst of all of this, when we talk about interest and rights, populations are increasing exponentially. And as far as access to land is concerned, the land is not increasing, but the number of people who need access to this land is increasing. And I think something that we do need to take into consideration as a policy imperative is that we should look at how we use the land and also start to prioritize to say how much land should be utilized for the purposes of industrialization and manufacturing sector and warehouses. Because I do understand that that's also important as far as job creation is concerned and economic driving and economic expansion. But then the problem is when I look at documents such as the National Development Plan, it's not very clear as to what is the prioritization as far as our activities on our land usage is concerned. So I think that's something we do need to take into consideration. We shouldn't just think about land. I agree with Stephen on this point. We shouldn't just think about the land issue around agriculture. There's a lot of activities that are related to the usage of land. And as far as our economy is starting to complex, and as we're moving to the fourth industrial revolution and the likes, we do need to take into consideration that perhaps a certain amount of land needs to be allocated for other aspects of the economy. Thank you very much.
Thank you. And to the gentleman behind you there. Thank you, sir.
Thanks, Chair. My name is Wandi Silekahlani. I'm from the land reform. I'm a land reform practitioner. So I noted that previously at the beginning the professor was talking about the extent to which, in terms of the current enabling legislation and in terms of the constitution currently, we can theoretically, that's what he was saying, Professor Machaca, we can still have expropriation without compensation, theoretically, and I think this is a sticking issue that the judge was also trying to press upon, because it would seem to me that is basically difficult, and I think that is where, for instance, currently in terms of case law, we have no reference to that. With all the cases that we can talk to, that is where it's very difficult. I accept that, and I'm not favorable to the amendment as such, to allow for expropriation without compensation. But based on my own insights, I think what has been happening was that the departments and the commissions, what they've been doing has been to unduly basically rely overly on in determining the market value, in determining the amount to pay. They've been relying more on the market value basically. And as has been pointed out in the Constitution itself, Section 25 mentions 5 factors actually. Another one being the market value. But I think that is where we're getting to a situation where we're spending too much money and we're getting too little land. And I think that is where we have got this group, that dynamic and this debate in the country to say, basically, we're needing to roll out land to as many people as possible. But then because the land claim is not against the person who currently owns the land in terms of our law, the land claim is against the state. So the state has to find it within its parcel, its purse, to pay for all this land. And we're just talking land acquisition. And I think that is where we have a problem. Because when people are getting the land, they then also look to the government to say, government, you can't just put us on the land. You need to then support us to produce on the land. Because then the whole issue of food security as well. So where I'm sitting, I think, because other speakers were talking about the delivery mechanism to say maybe that is where we have a problem in terms of bureaucracy, maybe that is where we have a problem. I'm thinking where I'm sitting, the problem is our pairs. To what extent is our pairs going to be able to run, because it's a moving target? We have got land prices that are escalating. We have got a lot of people that are waiting on the queue to get the land. And because the state has to pay for this land, to what extent is our pairs, the national pairs, going to be sufficient to be able then to run out land? Suppose that you are able to fix and get the fastest and the most efficient mechanism then to research and do whatever. How are you going to get the land sufficient enough then to meet these needs? Because the state has to finance this. And I think that is where we need to be contextualizing this debate in terms of whether shouldn't be thinking about this exploration without compensation. Because the national purse itself, which is what has to be then utilized, is not going to be. And it doesn't look like, if you're looking in terms of the future with the downgrades and all of the, we are going to be there. I don't want to, I hope that the point has been. Has been,
no, I think we have it. We will respond to it. All right, let's pass on to this. Yeah, thank you there. Just get the microphone there, and then I will give the panelists a chance, and it will immediately, very small responses now, because this is not the final answer. We will just respond to the latest remarks, and I will keep it open to the audience. No, you, yeah. Sorry, I didn't even see a next one, but we'll take the next one after. Yes.
Thank you very much. My name is Ethel Phillips, a Goodwill Ambassador for Women and Children under CARA, NICSA, and Presidency. I thought, I'm surprised why we are still discussing this, because soon after Professor Muzeha finished, for me it was finished, and for a lot of us it was finished. He simply said, let's cut down all protocol.
You mean like the process? You mean like the whole process of evolution?
Yes,
it's not going
remove the red
on.
carpet and let everybody sit the way we are sitting. Fair. Now, since we are still talking, here is my point. Because after he finished, I actually found a point of entry from his point. Because after removing all protocol, then as every researcher, when you go into a community, you're trying to solve a problem, you have to find the key issues and the point of entry. The chief people, how do you do it? You have to find property owners. So, do we have a database at country level of property owners now and the previous? Do we, if we don't have, can it be a legitimate exercise? And then documentation can be obtained so that it becomes a process of reconciliation of the geometry, the geographical, and the boundaries of this problem. If this problem has got the geometry, you know, Ethiopia, they have a lot of things that have to do with mathematics. And which country did you say? Professor always speaks countries that have done a lot of old civilization. So all this old civilization can give us the dimensions of how we should come into a problem. Thank you.
Thank you very much. I think let's, for now, hand it back here. Okay, quickly come in before he goes to the back, seeing that it is there.
All right, good afternoon. I am Adima, the convener for Women on NICSA, which is National Interfaith Council of South Africa.
Sorry, say again, which is the what?
Wow, am I soft? Wow.
No, I just can't hear. I'm old.
Interfaith Council of South
Right.
Africa.
Yeah, thank you.
Yeah. I want to answer your question, why is Parliament taking so long? To answer that question, I'll say the problem had already been pointed to by Advocate Machaca. I'm sorry if I mentioned the name wrong. That Kenya deployment has people in positions of power that cannot execute that power. I will add to it by saying also, what is amazing is the Constitution was drafted and it was promulgated, but it was never disseminated to society. Therefore, society sits ignorant of the Constitution. We sit in small groups like this talking intellectually about the Constitution and stand up. But when we stand up, nobody else knows. I'll go back to Ms. Mabasa and say, national dialogue, is it a very difficult thing to do? I wonder. And we go to grandparents impregnating children from Professor Muzeha. And I will say on that one, it is not because of land. It is because of identity that was stripped of the people in 1835 when Macaulay said Africans have got to be deposed or dispossessed of everything they have, culture and all. So when you don't have a culture, you don't know what's right to do and what's wrong to do. And when you live to copy people, you don't know whether you're still copying or they're already following you, they're already at it. So heritage needs to be replaced over again. And the last that I want to say is, I don't know whether we remember last year in March, on the 30th of March, when the Concord made that infamous judgment that Parliament itself had assisted the President in violating the Constitution. And the Parliament still carries on doing the same thing, which shows this Constitution we're talking about is an unknown document. It has to go back and be taught to society through dialogue. It is there that we can forge national cohesion. Thank you.
Thank you. While the microphone comes to the front, please bring it to the panel members. On the Constitution being known, at the time when it was drafted, there was, of course, a very, very wide campaign to involve the public. Since then, I don't know. I personally don't know. While I was on the Constitutional Court, I often thought that one should restart a whole process of constitutional education. I don't know whether, the Bill of Rights itself, which is only Chapter 3, there's a small booklet of which the Constitutional Court a year or 2, 3 ago had thousands and thousands of copies. Perhaps one must find out where that process is, which is not a full constitution, but it is the part with the rights. So there is certainly a need for constitutional and legal education. Generally, that is very, very, very clear. At the time an effort was made, whether it was enough, I don't know. On the question of resources, this gentleman mentioned, of course, everything we have to do is within available resources. This job that I now have where I inspect prisons, when we first reported to Parliament, and Mr. Machaca, Dr. Machaca is the chair of the Portfolio Committee, my office members, as we all do, said we need more money, and we do. We do, because our prisons are 200% overcrowded. I've seen cells built for 20 people with 96 people in it. So for that we need money, and Dr. Machaca wisely said, you must realize you're not the only people coming here asking for money. We need houses, we need hospitals, we need school books, we need prisons. We need court buildings with windows that can close in winter. All of those things we need, and certainly money to expropriate land. Having said all of that, of course, often we have the money, and often government departments give back money because they simply did not spend it. And often it just disappears, which takes us into a whole new discussion. But an honest state administration is certainly necessary for any of these promises and rights in the Constitution to materialize. Enough from my side. I think take your turn as you feel like you want to say something. Yeah.
Yes, Judge, I'd like just to join you in saying that I think that the question of resources is a real question. One of the mandates of the South African Human Rights Commission is exactly to do that, to develop a culture of human rights, and it requires that people should know what their rights are. It therefore means that there should be outreach in terms of supplying constitutions, in terms of reaching out to people and telling them about what their rights are and so on. But the amount of limited, or the problem of limited resources just doesn't make it possible for the institution to reach the 55 million people within a very short period of time and do all that which is being done. But having said that, there are new programs that are being developed by the Human Rights Commission in partnership with civil society and other stakeholders to try and do exactly that, to try and reach as many people as possible. But the Commission alone will not be able to do this within a very short period of time. There is also a need for the management of expectations, because the expectations are that because it is in the Constitution, it must be done tomorrow. While we all admit that everybody is asking for money and that there is no money anywhere, my sense is that perhaps somebody somewhere needs to do an expectations management exercise. I would like to come back to the issue raised by Ms. Kahlani about the difficulty of the whole issue of expropriation without compensation. My sense is that perhaps your question arises from the assumption that compensation must be based on the market values of land or property. Whereas we think that you can depart from that because Section 25 actually allows that. And there have been court decisions, I think the Detroit decision versus the Minister of Transport, which says that you don't just take one of the factors stated in Section 25, you must balance all of them and not give prominence just one. I think that one of the mistakes we've been making is to give prominence to only just one of them. And also we have, to an extent, I think we have neglected to use Section 25(8), which enables the government to pass legislation or to adopt a policy, but I think better still to pass legislation that would enable it to pay compensation other than market-related compensation.
Yes?
Thank you, Professor. Just to maybe clarify my earlier observations that the judge has made, I think the fact that Section 25 exists on its own is not all the work that the state needs to do. So Section 25, we cannot run away from the fact that there are existing tensions, and we understand the context, we understand why they're there. I think over and above Section 25, there's got to be, and there is an obligation. I'm going to read a part from the preamble, which starts off with "We, the people of South Africa," and then carries on, but I want to go back to this. "We therefore, through our freely elected representatives, adopt this Constitution as a supreme law of this Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundations for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by law. Improve the quality of all citizens and free the potential of each person." Now, this is what the people, you and I, have agreed to do. So the fact that there's this tension in Section 21 is not the end of the story. What should happen beyond that is that the people of South Africa, with government, must then find a way to reconcile that existing tension. The judges in courts can interpret, how to reconcile Section 25(8) and Section 25. But what I'm saying is this: what is contained in this preamble poses a further duty on ourselves to keep thinking about the issues, and part of that is saying nothing in the Constitution says you have a right to property. So therefore, where is the harm in saying let's look at other ways in which there could be access to property, including leasehold, including limiting the extent of property ownership. We sit currently in South Africa where lucrative land is currently in the hands of a minority, even with jurisprudence and court cases having been found in the constitutional courts. We're still grappling with an issue of individuals owning significant amounts of land where the majority remains landless. So I'm not necessarily saying that it's the Constitution itself that's the problem. I'm saying the way in which we have chosen to think about the right to property is something that we need to look at and look at quite closely. Because, and it goes back to the other issue again of willing buyer, willing seller. Willing buyer, willing seller is not a constitutional concept. It was an ANC policy. It was the ANC that decided to follow that policy, which in fact was not as a result of the Constitution. So I think it's important to make that clear distinction between what the Constitution says and what has happened on the ground.
Just pass on to Dr. Machaca there.
Chair, if I just may through you whilst it's going to Prof. Machaca, I was just reminded when Ethel, I think, spoke, and she spoke about the red carpet and within the context of what Professor Machaca had spoken about so eloquently in terms of our African humanity and our African genius. It also raised another question which I'm just going to ask perhaps the Prof to expand upon. He spoke a little bit about enabling legislation, but he also spoke about scrapping legislation that is standing in the way of accelerated implementation of land distribution. And I was just wondering, Prof. Machaca, if you might just expand a little bit on the kinds of legislation that you think might possibly be standing in the way, that is superfluous and perhaps not as useful and as optimal as we think it should be. Thanks. Thank you, Chair.
Yes. You know, I'm not sure that, I'm sure that some people who acquired land earlier on did not even pay for it. I come from Bulobedu Kwimujaji. She waged war of resistance because the Transvaal Republic said any white farmer who is not afraid, he can walk around and mark out the boundaries of the land he wanted. And that land belonged to the Balobedu of Mujaji the Railway. But there are other people who bought land from those who got it for free. And they went to the bank and borrowed money. So if we expropriate without compensation, are we not creating justice through injustice? Now, if we are prepared to do that, are we also prepared to say any black person who acquired farms from 1994 until now must also lose that land? Because that's what a law of general application will mean. Otherwise, we must make a law which says that all white people who have land, we can expropriate without compensation. But if the land was acquired by black people, there is compensation. Can we say that? And that's why I want to agree with Lemavasa that we really need a national dialogue on these matters, because we want to create a just society, and we can't create it on the basis of injustice to other sections of the society. I also want to agree that resources are a problem, because one could even argue that our people were in struggle for more than 300 years. They died during the course of that struggle. Now, after the democratic breakthrough of 1994, the people who were in struggle for 300 years must go and buy the land. Now the question would be, what were they struggling for if they have to buy the land? But that, at the same time, cannot mean that we must perpetuate an injustice on other sections of our society. And that's why we need a national dialogue. I think you don't need old brains like mine. We need the younger people to help us, because if we are going to be reckless about the matter, we may go back 300 years ago. We can destroy the country, and to rebuild it, it won't be easy. So I think that finding resources to buy back the land is not going to be easy. And now, what do we do? So that is the question that the younger people must address. But I can tell you, Professor Van Vestes talked about an anti-Bill of Rights committee that I brought to this university to oppose human rights. And then, the ANC in exile also gave us money to debate the issues. And from that conference, the young people had positions which we placed before the ANC. They rejected some of the things and they accepted some of the things. But our university students now are too quiet. too quiet, except when there is unrest. So my proposal would be, I said that to the law students at Nelson Mandela University, that we need the young brains now to solve our problems. And as chairperson of the Justice Committee in Parliament, I tell you I can even ensure that I fund an endowment for the law students. We lock them away for a week. Let them go and debate these issues and tell us what are the solutions, provided those solutions are not going to take us 300 years back, because our people have suffered long enough. They don't need no struggles. They need us to use our brains and the law to change things. But lastly, I just want to say that Ms. Mwalima spoke about reviving the culture. The organization of the African Union came up with the Charter for African Cultural Renaissance, which can help us deal with this question of heritage. But since the government has signed it up, it is quiet, there's nobody to implement it. So implementation is also our problem. Similarly, in this land question, there are lots of things, if we had implemented, we would not be at this point where we think that the constitution is wrong. We say it's wrong because even where it is right, we don't do the right thing. Lastly, on the students, I want to say that the students no law students must get an LLB degree unless they have passed one or the other African language. And that African language departments must also be really established at all universities. Because if you don't know Tsonga, Venda, Zulu, you are a judge, you are a prosecutor, you are an advocate, how do you defend people whose language you don't understand? Because the majority of the people don't understand your English, but you say you are representing them. So when some of us studied law, Afrikaans, English, and Latin was compulsory. So this time, Zulu or Tsonga or Venda or Kiloleli must be compulsory before you get law degrees. But also, it must be compulsory for law students to do community work. You mustn't get a certificate unless there's evidence of community work, because if you don't do community work, you won't develop a social conscience, because law is not about applying rules. It's about concern about the aspirations of the people, the interests of the people, and so on. So law is like being a pastor. It's a calling. It's not something that you do because you want more money. The enabling legislation we're talking about is the Community Property Association. That property association creates two centers of power in communities, and therefore plants the seeds for conflict in our community. And that negatives our efforts to create socially cohesive societies. So I want to say Community Property Association and Land Restitution Act. I want to ask students to go and write assignments on how we can scrap these things. So when we open Parliament in July, you must send us proposals how we can scrap these things, because I will still want to.
Okay, thank you. Thank you very much. You want here, or should I write? No. Oh, you want? Okay, quickly.
Very quickly, on the question of implementation, Professor, the Department of Land Reform and Rural Development consistently gets less than 1% of the national budget. Yet politicians say the land question is significant and important. I think there, it's shooting our foot to spite our nose. If we want to solve the land question seriously, we cannot, in all seriousness, have it allocated less than 1% of the national budget.
Thank you. Professor Machaca said we need young brains. There are quite a number of young brains here, and I'll get you right now. But before that, one light-hearted comment and one serious one. You mentioned how some Boer farmers got land without paying anything for it and so on. Yesterday I was in Lesotho, where I acted on their Court of Appeals, and I went for the second time, I was there last year as well, to visit Thaba Bosiu, the mountain on which King Moshoeshoe and his people lived, and where he actually, if I understand the story correctly, actually founded the Basotho nation. But the funny part is, in my school history books, I grew up in apartheid South Africa, we were told that the Basothos stole the cattle of the white Boer, and then they fled up the mountain, and then the Boer couldn't get to them, but they tried to get there in the night. Now, I heard the story from both sides. Now, the story is that Sangoma helped King Moshoeshoe, and they put ropes around the mountain, and they put some magic stuff on it. So when people try to climb up the mountain, they fall asleep when they get to the ropes. And then they think, they especially when they do it at night, they think they're close to the top, and when they wake up, they see the whole mountain is, and then they believe that the mountain was growing at night. But eventually, there is a town in the Free State called Wepener, and this town is named after the Boer hero Lou Wepener, who led a commando of Boer trying to get up the mountain. So I read in the museum there yesterday, there were actually two wars between the so-called Basotho Boer wars, and but as to what started it, my school history book said it's because they stole the cattle. So I thought there must be another reason. But when we walked to the museum yesterday, the official guide said there were two Basotho Boer wars. He said, and the reason why there were wars is because the Basothos went and they stole the animals of the white farmers. So I said, that cannot be, because that's what my school history books told me. So later I saw a more nuanced explanation in the museum itself, which had a lot to do with land, of course. With land that was taken away, and with reprisals and therefore incursions, etc. On a more serious note, I see there are students in the audience, there are student activists. You called for young brains. Last year I did a number of projects. One was on this university and one was at Free State University, which had to do with the so-called student unrest And after listening, especially on the Free State campus, I listened to witnesses. I listened for weeks to witnesses who participated, who came and sat right across the table for me. One of them, for example, a man with the telling name of Muammar, as in Gaddafi, Muammar Muafrika, who in the meeting before the hearing started stood up and he said he will never go and talk to a white person. And he and his group have their own constitution, because the constitution of South Africa is a white people's constitution. But eventually he came and he gave evidence. And when he spoke I said, but I thought you will never, you against the white. He said, no, he was taught that one should not trust a white man ever. I said, well, I don't really care if you trust me. No, just tell me your story. And then you will see when I write the report if you could trust me or not. But to make a long story short, through that whole experience, I came to the conclusion that the bottom of all our problems is poverty. Poverty is at the heart of most of our problems. Obviously, it is interlinked with land. And then when you add a strong touch of racism to it, like on that campus, then you have real trouble. If you have a campus, not this one I did other projects last year on the language policy and so on, but not the specific conflicts. If you have an enclosed campus, and half of the students are the children of farm owners, mostly white, although we don't talk race. They drive over the campus in 4x4s. The other half of the students come from townships, and they are the children of farm workers. And they say to you with tears in their eyes while they give evidence that when they see these white guys on the rugby stadium, because it had to do with a fight on the rugby, with an attack on the rugby field, they see people with farmers' hats and boots, even though the students are wearing sandals and rugby shorts. And they see in their eyes that they look at them and they say, you work for me. That is, and we are together on this campus. Then if you add then practices, which I could not believe, but you know, on that campus, those of you who are foreign students, a few years ago there was a very unfortunate incident where white students initiated, as part of their initiation ceremony or whatever, in a very racist male residence, they forced workers, domestic workers, to run in races, and they forced them to drink urine, or at least to drink stuff that they were made to believe was urine. Now, that thing was investigated, and the chair of council spoke against it, and none of the students eventually got a serious punishment. Now, you will not believe that after that, incidents like that still happen. People drive with 4x4s over the campus and throw stuff that looks like urine. Maybe it's tea, maybe it's Coke, maybe it's rooibos, whatever. And then they throw it over black female security guards, for example. And then the university's response is, oh, we sent it away for DNA, whatever it is, for testing, and it's not urine. So what now? Does it make it okay? If you catch Jewish people in the heart of Berlin and you blindfold them and you march them into a garage and you put a poster up there which says this is a gas chamber, and you scare the living daylights out of them, and after you say, you're so stupid, you think it's a gas chamber, actually it's this local farmer's wine cellar. Does that make it any? In fact, I think it makes it worse. So what I'm trying to say, and I would like to hear the comments from it, at the bottom of so many of our problems is poverty, and then especially the differences between rich and poor, which is, of course, then related to the possession of land, ownership of land, and which, of course, is then directly related to racist practices. So how to solve it, of course, I have no idea. I leave that to the young brains, which I will now give an opportunity to respond. Yes, sir. Just take the microphone there. Just your name, and not too long. I know I speak for too long. Don't follow my example. Speak briefly so that we can give a few more people a chance before we break up.
Thanks for the opportunity. My name is Maisha. I'm a folist. When I mean I'm a folist, I belong to Feast Must Fall, Rose Must Fall, Africans Must Fall, all those things. So the issue of the land has been a part of Feast Must Fall and has been part of us. So what I will say is that I will criticize Prof. Machaca. Prof. Machaca is the same person who is in parliament. They are the same people who voted against the land issue when the EFF proposed that they give them 6% to expropriate the land without compensation. Part of our problems in South Africa is that we are failed by the ruling government, the ANC government. And to say that the land issue is not a racial issue, I don't believe in that. The land issue is a racial issue, because go to Mamelodi, go and check those squatter camps. They are black people. White people, they don't have problems with the land. They've occupied the beautiful land of Africa, of South Africa. Go to Montana, it's their homes. Go to Mamelodi and see that people really need the land. Black people need the land. But because with people like Machaca, they are on our way. They make us landless. I'm landless currently. I'm staying in a shack because of Prof. Machaca. It's in parliament. He voted against that we must not expropriate the land without compensation. So I'm asking a question. As a student, how will I get money to buy a land? I'm a student. Where will I get that money?
Yeah, thank you.
Given the issue of free education is related to the land, we must get the land and get the resources to fund free education in our country. Thanks.
Thank you, sir. Just pass on, I think, there. Oh, you want to speak first, and then in the corner there.
I was the second one off the list.
Oh, okay, sorry, I didn't see you.
The house before I make a couple of comments regarding this issue.
Let me just say, let's try to be not very personal, although politicians deserve it, and I think Dr. Machaca doesn't mind at all. Yeah.
It doesn't matter.
Yeah.
The land issue, according to my understanding, it's a very sensitive issue. And in order for you to understand how sensitive the issue is, you need to first travel around South Africa and see the huge farms that De Beer owns, and see the huge farms that are owned by white people in South Africa. And the most disheartening thing out of everything is that the cradle of humankind is privately owned. Our own SNC, our belonging, where we come from, historical information is privately owned. The National Kruger Park is also privately owned, which is also disheartening in itself, within itself, because there's a whole lot of things that I actually wanted to talk about, but my brain is also doing some funny things right now. So
Take a deep breath, and I'll give you the microphone back to you.
No, I'm cool, calm, and collected.
Okay.
When you look at South Africa as a country, there's huge problems that keep on arising. Different problems of education, economy, the land issue, the healthcare system. A variety of problems always arise in South Africa. And when you start to look at these problems, fundamentally speaking, and go to the root of the problem and combining all of these issues that arise, you actually get a sense of understanding that all of these problems go back to resources. Everything is fundamentally based on resources. Even on the land issue, even on the expropriation of the land without compensation or with compensation, it's also a very difficult topic within itself and should be treated as such. We know the history of this country, and I think we shouldn't indulge in that topic in lengthy discussion, because it's not going to solve any problem. What we currently face in South Africa is that, as it stands, the majority of the economy is not owned by the majority of the people in this country. Even the land itself is not owned by the majority of South Africa. Now, when you tend to say that land should be expropriated with compensation, it tends to raise a whole lot of difficult questions, because it's also going to come and it's also going to raise the question of where is the money going to come from in order for the government to compensate for all of these issues, since the majority of the economy in South Africa is not owned by the government itself. It's not owned by a huge portion of it, according to my understanding, is that it's owned internationally, and another significant amount of the portion is also owned privately here in South Africa. So when you say that there's some sort of compensation that needs to happen in accordance, it raises a whole lot of technical problems, and it's going to be a lengthy discussion in terms of how we can draft solutions and solving that problem. So in my analysis and the observations that I've made in the recent past is that there's been 23 years of democracy, South Africa living under a constitutional democracy. And whether it's the fault of the ANC, whether it's the fault of the white monopoly capital, whether it's the fault of any person or any individual responsible, it's not going to solve the problem. What should happen in this country is that Section 25 of the Constitution should be amended, and it should be amended as such that it's expropriation of land without compensation, because black people as it stands, we do not have the necessary resources and to cushion that compensation side. That's the reason why I believe that land should be compensated, expropriated without being compensation. Thank you.
Thank you. While you pass the microphone there, I see several hands here, but pass it to the corner. Sir, just two small things. Sir, the speaker, I didn't know about the Cradle of Humankind, but Kruger Park, isn't that owned by or at least run by the National Parks Board, which makes it, what is the National Parks Board? Is it some kind of government? Yeah, I know, yeah, but it's not private, it's part of, it's parastatal. Okay, but when you say the Section 25 must be amended, we heard Professor Majola and others say it's not necessary because it is already possible to compensate, to expropriate without compensation. But just for my own personal interest, I'm not a politician, I cannot make laws, but if anybody ever says again the Constitution must be amended, I would be very open, provided that I see the amendment. What must it look like? So I'm here on the campus. Please feel and come and talk to me. I would like to write about it. I'm in this little that house next to the law faculty. And I would like to see these proposals, because one thing that we must stop doing is to talk around. I'm not saying that's what you're doing. That's what we all are doing. We talk around in circles, and we talk about paradigms and all kinds of stuff. And the question is, what now? What next? We cannot keep saying this discussion is so difficult that we don't even want to start it. We cannot say that. I cannot see that will bring us anywhere. Or that we must first do this and that and destroy something or whatever before we can even talk. If we want to do something, we must do it, and in order to decide what to do, we must talk about it immediately as if it is extremely urgent. Not make the whole process. My problem with some of the intellectual discussions on universities, whenever you start something and try to talk about something, people say this process doesn't have legitimacy. Now, did you want a general election before this panel is elected to be able to sit here? You know, sometimes small groups, as Dr. Machaca spoke, we came together here on this campus and other places in small groups. Nobody elected us. We did it because we felt it has to be done, not because somebody gave us a mandate or whatever. All right, sorry for my long speech again, in the corner, and then the lady in red, and then here. Yes? Yeah.
Thank you, Judge. I just want to raise an issue. I don't think anyone has raised it before. It also relates to, oh, by the way, I'm Mpomolefe from the National Interfaith Council of South Africa.
All right, can I ask you a favor? I have to run to the bathroom. When you finish, pass it on to the next speaker. and this panelist will control proceedings in case it gets out of hand.
I'll do so. Okay, my problem is again with Section 25 of the Constitution, in particular 25(7), which says that a person of community dispossessed of property after the 19th of June 1913 can claim. Now, I don't know what is so magical about 19th June 1913, except that the 1913 Land Act was in actual fact legitimizing the theft that had already taken place. It was now legalizing what the colonizers had already done, that is to say, forcefully take land away from our people. I think this must also be amended so that it can go back at least by another 50, if not even 100 years, as long as people can be able to prove that they've got a claim to that land. The young lion who was speaking now was giving an example about Mamelodi that is staying in a shack there and they don't have access to land. I just want to give an example about Mamelodi as well. I come from a church called African Church. African Church bought a farm called Vlakfontein, and that was in 1908. And then the government then made sure that our church does not get the necessary finance to complete the transaction. The in actual fact gave instructions to the building societies not to fund that transaction. And as a result, the church ended up losing that land, Vlakfontein, which is the present day Mamelodi where he stays. Now, I would like to see this taken back so that, for instance, a farm like Vlakfontein, Mamelodi, can go back to its rightful owners. And there must be there must be expropriation without compensation. Unfortunately, it stays in the check there. It means that it's going to be moved without compensation. Thank you.
Sorry, just for the benefit of the judge, the issue was the Restitution of Land Act makes provision for land to be restored from 19 June 1913. And Pomolif is asking what is the magic behind the date, except for the fact that this when the Native Land Act was enacted. But his argument is that by 1913, already there was a huge chunk of land that was dispossessed in any event. So what is the real utility of using 1913 as a date?
Right, Bryson? Yes, thank you. Thank you very much.
You asked how could we find ourselves in a position where we're able to move forward and find solutions. There's no way we can know how to fix the land issue if we don't know where we came from or how we got here. The reason why students feel it's okay to throw urine at someone is because they don't know our history. According to them, Rachel de Beer or whoever it is a hero in their circles. They don't understand who Solomon Machaca is, and they don't understand the unique situation South Africa finds it in. We're the only one of the very few countries who still live with colonizers, and because of that, we have to find very unique solutions as to how do we address the land issue. And we cannot do that if we do not know what our history is. It needs to be taught to us, the foreigners or whoever we are, from the get-go, so that people can get to a position where they understand what is white privilege, what does it mean, and how does it negatively affect my black brother who has to take a taxi to school as opposed to me who's able to be driven to school or walk to school.
That is what I refer to as the Free State thing. I don't know about Rachel de Beer, but I think unless one is deeply racist, your common sense and your general feeling of humanity would tell you that it's not right to throw urine over anybody. But of course, if you are steeped in that kind of thought, and especially if you become anxious that you will lose your privileges, you resort to those kinds of perversities in order to retain your control and your own feeling of superiority. There was somebody there? Yes, sir.
Yes, thank you. My name is Mobani Nyacha. I'm a student at the University of Pretoria. I'm from Zimbabwe.
Oh, yes. Here we have the solution now, guys.
Yes, we have progress led without compensation. And I've been listening attentively since morning. And, well, it might sound condescending, but I think that what I heard is all talk. And no one has put forward a model for that appropriation without compensation. Because in Zimbabwe, that kind of law, do we want to follow the same route? If so, can someone explain how? Because ours, it's a very complex situation, because ours involves ousting the jurisdiction of the court. Because if you say that you are amending Section 25, that is exactly what is going to lead to. Because you can't, it's almost impossible to expropriate land without compensation with the scrutiny of the courts and with the courts reviewing that decision. Because ultimately the decision will come to expropriate land without compensation will come from the executive. What safeguards do you have? So I would want to hear someone maybe explain that, because for someone else in there, I think it's just all talk and nothing more.
Sorry, let me just clearly understand what you're saying. Are you saying one should be very careful to amend and exclude the courts? Or
yes, I just want to hear what the amendment is going to look like. Because in my view, it may need to exclude the jurisdiction of the courts, because I don't see how you will want to expropriate land without compensation and escape the scrutiny of the court.
Okay, perhaps just, but my legal friends can add to this. Just on this whole issue of courts, I don't think we must overestimate the Constitution and the law, and also not underestimate it. When Professor Machaca talks about all law students must get together and so on, I think certainly also other students. I don't think these issues are just for lawyers. And my colleague here talked about lawyers in their smart offices in Sandton and so on. Let's not. The Constitution cannot solve all our problems. It must allow for it, and it must give a framework within which it can happen. We do not want a judge to sit and decide who must get a farm, or what the amount must be, or whether a sheep farm is worth more than an ostrich farm or whatever. I, as a judge, cannot decide that. I don't have that knowledge. But what we do want, otherwise we're in big trouble, is scrutiny by courts. Not because judges are so clever, not because they're always right, but because history has shown that if you do not have the rule of law, and if you say the president or the king or the Hitler's brown shirts or whoever are not subject to courts, then you are heading straight for very, 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 very serious problems. And that doesn't mean we say that the courts are always correct. That doesn't mean that we think that judges are clever or that lawyers should make all the money that they are making. It simply means that democracy as we nowadays know it, scrutiny by courts is a very essential element, provided that the courts don't interfere in things that are none of their business. Thank you. Yeah. Was there one more there? And then I give panel, and then I'll come back to you. Sir, yeah, there in the corner? Yes, that hand there. Have you got the microphone? All right, let's take the gentleman at the back also, and then definitely the panel, and then the organizers must tell me whether we still have time. Yes, there, to her, to that lady. And then there's a gentleman right at the back after, yeah, right.
Hello everyone, my name is Memory Sosibo. I'm from the National Association of Democratic Lawyers. And mine is more of a comment sort of question. Mine is, I think we need to relook at how we look at the issue of land. It seems as if we move on the narrative that acquiring of land or redistribution of land is an end in itself and not a means to an end. We need to clearly identify what is the objective or the reason behind land reform or land redistribution. Once we understand that, then we can actually deal with the land issue properly. Because right now, I believe we sit in a situation where, even with the very few cases of land redistribution, we find that people are not specifically benefiting from the land redistribution. How do we now structure the process into such a way that people actually benefit from the land? Because we find, especially let's say in urban redistribution, we find that most people opt for the option of money, of cash compensation as opposed to actual land. Is that really what we want to achieve? What are the underlying processes, and what is the aim at the end, ultimately, of land reform and land distribution? Once we put our minds there, I believe then we can come up with proper answers. In my opinion, the answer, I believe that what we seek to achieve is equality in society. We want to ensure that we have a society where everybody is able to share in the resources. I do not believe in an extreme leftist approach whereby we now replace the old oppressors with new oppressors. That's not the aim. The aim is to make sure that everyone who lives in South Africa benefits from the resources of the country.
Thank you. Gentlemen, okay, now there's another hand.
Who's benefiting right now, I think that perhaps goes to the past. We look at the past and say, yes, there are injustices. Yes, currently we sit, the people who are not benefiting from the land may be black. But what we are trying to do is get to a point where we say there's equality in South Africa, not in a place where we're replacing one oppressor with another oppressor. That can never be the South Africa that we wish to achieve.
Okay, thank you. Pass to the gentleman at the back, and then I will, yes, it's you. Then I will give to the gentleman in the red shirt. I wonder what red means, but yeah, I will give to you. Then the organizers told me 3 minutes ago that there's 10 minutes left, so there's now 7 minutes left. So the two of you, and then I'll give the panelists a chance, and then we'll see what time it is. Yes, sir.
Hi everyone, my name is Thomas. I'd just like to begin by saying I share the judge's position, or rather his interest, in seeing what such an amended Section 25 would in fact look like. I don't think there's been too much engagement with respect to what the new piece of legislation, that specific provision, would in fact look like, and what the consequences of such a provision would be. The second thing is in relation to the professor. While I personally don't believe you're responsible for people living in shacks, I do think reference was made by Machaca to the fact that the EFF did propose in Parliament a dealing with Section 25 of the Constitution and Julius Malema offered to give the EFF 6% to the ANC, to the African National Congress. Now, the ANC's chief whip, in response to this, said that the issue of land reform does not in fact rest with Section 25. He said we failed, making reference to the ANC when he says we, finished and clear. Those were his exact words. But the next week, you see President Jacob Zuma saying black parties should have in fact united with respect to the issue of land reform and used the opportunity given to the ANC by the EFF in order to deal with the specific problem. Now, I wanted to ask whether or not these inconsistencies with respect to the ruling party, where you have the chief whip contradicting the president, something that has in fact happened numerous times, is a part, as party exacerbated the problem with respect to land reform.
Okay, thank you. Gentleman in the right shirt, that's the last one before I come to the panel.
Thank you very much. My name is Usman Khalil, so surprise. I want to challenge my dearest lady and my brother there. Because you see, the issue of land, as we know very well, is a national bone of contention. We don't speak about expropriating the land without compensation because we lack substance to it. For sure, we know and we make differentiation to say we want to expropriate the land for 1, 2, 3, 5 public purposes and interest. To come and say that for what reason are we pushing for the expropriation of land without compensation? I think it's selective amnesia, unfortunately. So coming to my brother, in Zimbabwe what happened, you know very well, and it's so hard, it's so disheartening because it seems as if you don't have a track of what's happening in your country, what has transpired in your country. In Zimbabwe what happened, it was indigenization compared to expropriation of the land without compensation. I don't agree in a manner that practice was sort of handled, but I agree in principle with the principle that land actually must be restored to the people as a whole. Actually, the state must own the land, not few individuals like what has happened in Zimbabwe. My brother, I commend what Robert Mugabe has done in Zimbabwe to sort of explore that indeed we need to get our land back and to reclaim our dignity. But to say it must be given to a portion of an ethnicity or whatsoever grouping and so on is wrong. In South Africa, what you are currently proposing is that the land must be owned by the state. Whether from white or you are black, it must be expropriated. There are chiefs who are owning a chance of land. That land must be expropriated as compensation for public use. And whites must stop being reactionary and crying babies because they are not the only one who are controlling all the land, but they sort of own the significant portion of it. They are chiefs, they are kings and so on and so on. They own the land. To also want to expropriate those farms that they own for public usage. Thank you very much.
Thank you. All right, let's now leave the audience. Thank you, sir. You by raising the fact that chiefs own land or control land, that's very important because the gender issue we never came to today, and perhaps that is a discussion for another topic. The effect of traditional leadership on the situation of women with regard to taxing powers and ownership and so on. So have my panel decided to start on that side or this side? I think Mr. Machaca is the one who is now going to finish off the EFF right here.
You know, in Parliament, I respect all political parties, including the EFF. And I don't differ with any one of them because of the labels, but because of the substance. Even if the EFF can make another proposal that they will give the ANC 6%, I'll be one of those who say no, we don't want 6%, because we don't want to rent a crowd against any section of the Constitution or against any person or party. What we have to ensure is that the decisions that we take in the National Assembly are the decisions that we can explain to the satisfaction of the people of South Africa. Because our presence in Parliament is not a matter between the ANC and the EFF. If they are both mad, I will not support both of them. I want to be convinced that what the ANC and the EFF agree to would make sense to all sensible South Africans. You know, someone said here, and I think Ms. Mabaso, the chair, said, put a model on the table to say this is how we want to change the Constitution. And this is what we want to achieve by that change. But to change the Constitution when you don't know what you will do the next day doesn't make sense. So as matters stands now, both the EFF, the ANC, and all parties in Parliament have not said anything convincing why we should amend Section 25, except that the land restitution process is slow. And I think my learned friends have shown why the process is slow. And if the process could be speeded up, we would even forget the amendment because we would get what we need to achieve. So I'm sorry, I will never accept any 6%. I don't need any 6%. And if my party accepts the 6%, I will abstain from voting. But you see the inconsistencies between the chief whip of the ANC, Comrade Jackson Mthembu, and President Jacob Zuma. You must understand that President Jacob Zuma and Jackson Mthembu are individual members of the ANC. The ANC policy is not determined by individuals. And that's why we are going to a policy conference. So they have expressed their opinions. They are entitled to do so. But I personally would also not support an idea which says black parties must gang up against other people. Why should black parties gang up unless people have become racist? Parties in parliament, regardless of their color, must seek something that will be just to do. The South African Incorporated. That's what I will support. So I'm not interested in color because after all, for me, we have different colors because of the heat. Others are light complexions, others are very dark, depending on how much heat the sun has been through. So color is not important. We are interested in justice for all, whether people are white or black. Justice must be accessed by all people. You know, President Robert Mugabe, I don't think that he wanted to take land away from people. He acted out of anger because the British betrayed him. They said that they will sponsor the settlement, and then they didn't. And then out of anger, he acted. So we are not yet angry. We are not yet angry because we have platforms to address our problems. So I want to repeat that both the EFF, law students, and other students, let's work together to come up with a model. And then I don't think anyone would resist a model. What is the magic with 19th of June 1930? I agree with Mr. Jamulef. In 1933, it was the 1930, it was the institutionalization of land disposition which had already taken place. And that's why in 1913, black people only had 7% of the land. And it was increased to 9 to 13%. So if you say there's a cut-off date, it means the claim must be, you claim what is within the 13%. And that 13% consisted of native reserves which were barren which were not producing anything. So the cut-off date is wrong. But now the question, how far back do you go? And that must be a matter of debate, and we want the EFF and the students to take part in that debate to say how far back do we go. But if you go too far, the Khoisan will say, no, all of you Bantus, you came from the north, you found us here, so this land is our land. So it's not an easy thing. Lastly, Chairperson, I think it was the lady from Nadel who supported others that let's work on a model of what we want to achieve. Not just say amend this, don't amend this. Let's produce a model. I think that this process we started, Professor Quinton and my learned friend, must continue. And also the church, Bishop, the church, you know, I like his patience. To sit here attentively is very commendable. You see, the churches would also have interfaith dialogue to talk about these matters. So on the 30th of April, we are starting our national interfaith dialogue. I want you to chair that dialogue because I can see you are interested in the future of the people. Thank you very much.
Thank you. Can I'm not the boss here, so I am. It's been shown to me that we have a time issue. No, please feel free to make concluding remarks. Yeah. No, you conclude, but not just about children, because you were not accused of having causing people to live in shacks.
I don't know if our colleagues want to perhaps say a short word in conclusion, and then we can wrap it in the next, say, 5 or 7 minutes.
Yeah. Okay.
Well, thank you very much, Professor. I'd just like to conclude by saying that it's been a very interesting and eye-opening discussion for me. Obviously, we need to do a lot more talking. From our side in the Human Rights Commission, I have already said that we do not support expropriation without compensation, and I even referred to international conventions, and that's our standpoint. However, we also do not support expropriation at market value. We think that there is a possibility that compensation can be fixed at a particular level, so that even the landowner is left with a bit of dignity, and his or her property is not taken completely. But I would be very much interested also to see the model that those who think that we should amend Section 25 will produce, because perhaps it could also change the view that I have that it is not necessary to amend the Constitution. Thank you.
I think in conclusion, what today has reiterated, at least for me, is that the work of the land question doesn't reside just with judges or lawyers. That is the work that needs to be done by every sector of society and every sector of South Africa, and that healthy debates and questioning whether things have worked is something that must happen, that we mustn't be fearful of, that we mustn't be frowning upon. And I also support the idea that the student movement has a very crucial role to play in coming up with potential solutions. And I think that we are not in a perfect situation, that's why we're sitting here. I think we shouldn't be afraid to say that things haven't worked perfectly, and that even with the constitutional dispensation that we have, it hasn't delivered the desired results, whether it's implementation or whether it's how the law has been interpreted. Thanks.
Thank you very much. Very last remark from my side is at the end of January last year, my term in the Constitutional Court ended, and there was a very nice farewell function for me. And a few months later, there was one when Deputy Chief Justice Moseneke also left the court. Both those occasions, when one attended it, it was extremely inspirational because people talked about the values of Nelson Mandela, they talked about the rule of law, they talked about our wonderful constitution. We all hugged each other. I got tears in my eyes and we were very inspired. However, immediately afterwards, I got thrown into some of the issues on the campuses. I've mentioned Free State, Pretoria. I have not had much contact with the students here, but I try to chair certain things. I led the committee panel regarding language, and the whole fees must fall and all of those things. And I sometimes thought that we are living in two different worlds, and I think our colleagues in Parliament, I don't know to what extent they are in touch with constituencies. I don't even know to what extent university management is always in touch with their students. I don't know to what extent the Human Rights Commission, I can just speak for myself, is that of course we must believe in the ideals of Nelson Mandela, and I will not join any group or any trend who says that he was a sellout, etc. However, we must realize that amongst young people there is a tremendous frustration and anger and heartbreak and pain. So whereas I would never in my life condone the burning of a library or a school, I can understand that if one comes from Limpopo with English as your fourth language and you sit in a classroom next to the guy who got 6 distinctions at Affie's down the road and who still insist on getting his education in Afrikaans, and who drives over the campus with his father's 4x4, whereas you sleep in the library, or like I was told at Stellenbosch, have to put your mattress under somebody else's bed, or in a basement somewhere where the security won't see you. I do understand the anger, and like I said, seeing it close up, it turns from anger into pain. That I do understand, and I think we must all try to understand both sides. However, back to what my colleagues have said, it will not help if we simply say, let's destroy everything. That will take us back, I don't know, 300 or however many years back. We have to think of a plan. We have to think of a plan. We have to get our house in order. We have to choose our leaders. We cannot walk out of meetings because we argue about who the leader is or which faction belongs to who. And we have to tackle the things that are obviously at hand to make South Africa a better place for all who live in it, black and white. And with those words, thank you very, very much for the opportunity. It was quite exciting. During the last part of the morning session, I thought there would be nothing to talk about in the afternoon. And therefore, I invited some people in when I saw the red T-shirts in the area. So thank you for making things interesting. And I hand over to, I don't know if it's Professor Johnson or Ms. Machaca. Thank you.
Judge, thank you very much for chairing a lively session. When we began, this morning, we were talking about the fact that land and heritage and human rights are inextricably related to our most unfortunate history in our country of 300 plus years worth of apartheid and colonialism. And the focus with regard to Section 25 of our Constitution has for me been very illuminating today across many sectors. I especially pointed out the young people from the university this morning, as some of you would remember, because we certainly look to you, ourselves of course, but to you the future, to you and your ideas, to your understanding of the context, because we must be contextual, and how you believe that future needs to look. I think there's a common and reasonable consensus when we heard this morning from our keynote speaker, Professor Majola. He spoke eloquently about Section 25 and of course all matters related to it. And I think he demonstrated by case law, internationally and otherwise, that indeed expropriation must be accompanied by compensation. But he also mentioned the fact that there can, under certain circumstances, be expropriation without compensation. And of course the matter doesn't only have to relate to monetary value,
I think, Judge, you spoke about 5 other important factors in regard to how we assess the situation. They include, of course, the history of the property, its purpose, the investment matters surrounding it, and so on. And that was superb. I think Advocate Makua then took the matter forward and told us about the process and how important the process is, but how cumbersome the process actually is, and how that process oftentimes delays the implementation of what we want to see, most of us, if not all of us, as accelerated access to land within the framework of our Constitution. I think he mentioned cadre deployment as a challenge. I think he referred to the limited skill set in many instances around this matter at different spheres, of government. And then, of course, Professor Machaca, he told us very eloquently about our history and our humanity. And he also mentioned, of course, the fact, amongst others, that there's legislation that is enabling, and quite frankly, legislation that should be scrapped, as he amplified, earlier on today. I was very keenly interested in Ms. Mabasa's, concept of SA Incorporated, because it is SA Incorporated that ultimately has to fund, the purchase of the land, as we had discussed. And we all know how difficult, the economy in the country is today. And we see downgrading and what that means, to our economy, and we are concerned about that particular matter. And I like the concept of SA Incorporated because it includes all of us as we go forward. And then I just want to basically say that, in terms of reference, we've done a symposium like this last year, as I mentioned earlier this morning, and now we've done this particular symposium. And in terms of our next steps, we will carry on to do further symposia across the country so that we strengthen our social dialogue. We all know this is very, very important. We would rather have all the stakeholders inside the tent eating it up than some of us outside trying to burn it down. We are all in this together. It must be a shared future where there is growth and an inclusive economy, not just for some, but for all. And in the end, I'm sure you would agree, it's about the restoration of our dignity and the reclamation of our heritage. And then, Judge, you commented in the session about what now and what next. I earlier said that I work with young people as principal of our campus in the Southern Cape. And the young people told me and others in no uncertain terms, it is feast today and it will be land tomorrow. Why are we so labyrinthian? Why do we take so long to deal with these matters of great importance to us, the African people? Why must we wait? We've waited 300 plus years already. Surely we must by now have figured out intellectually and otherwise the actions we must take so that the African people have access to land and have access to land sooner rather than later within the rule of law. And so from where we sit, I just want to express my really sincere thanks to our partners. The University of Pretoria, there's Professor Fulun, he's returned. Frans, to you and your colleagues, Judge, to you at the university and everyone who's made it possible here. Thank you from our perspective very much, for hosting us. And then naturally, our Kara Heritage Institute and our CLC there for your leadership. Machaca will do all of this, I'm sure, now in closing. But I think we can't do it alone. We've never wanted to do it alone. It's impossible to do it alone. And we have that African saying that goes, if you want to go fast, then go alone. If you want to go slower, we must go together. And so with that, I just wanted to say thank you to all of you who have come at relatively short notice. There will be a general press statement that comes out of this meeting that will be distributed to the media. I believe that we are trending in the Twitter sphere already. I don't know if you've been following in regard to deliberations here. And so it's not only those of us in this room that have had the pleasure and the privilege of the engagement, but potentially very many millions outside that are following in the social media space. So I thank you very much. And let's welcome our program director back, Machaca.
would like to express our appreciation to speakers, delegates and partners at the Kara Heritage Institute, Nelson Mandela University, the Pretoria University, the Dutch Embassy, as well as Protea MENA, for the outstanding support of this dynamic symposium. Please also travel home safely. You are now invited for tea, and kindly give everybody who participated today a great round of applause.